On February 20th, 2026, the US Supreme Court did something historic. It struck down the legal foundation for most of President Trump's global tariffs in a 6-3 decision. Tariffs on Canada, Mexico, China, and nearly every country imposed under the emergency powers were ruled unconstitutional. But here's the twist. Within hours, Trump imposed new tariffs using a different law. So did Canada actually win? Or is it just a new chapter in trade wars? Let me break it down for you. Welcome back to KP Money Talks, and today we're unpacking the US Supreme Court's landmark tariff ruling, what it struck down, what's still standing, and why Canadian businesses and consumers aren't out of the woods yet. This is the biggest trade law development in decades and going to reshape how the US wields economic power globally. Hit that subscribe button for Canadian economic analysis on global events that actually affect you. Let's dive in. Let's start with what Supreme Court actually decided on February 20th, 2026. The case challenged President Trump's use of International Emergency Economic Powers Act to impose sweeping tariffs starting in early 2025. Trump has issued IEEPA to justify two major tariff waves. First, drug trafficking tariffs on Canada, Mexico, and China, ranging 25%, and 10 to 20% respectively, claiming an emergency related to fentanyl and illegal drugs. Second, reciprocal tariffs on virtually every country, a baseline 10% on all imports with higher rates for specific countries based on trade deficits. Some nations face 35% tariffs. These tariffs affected trillions of dollars in global trade and sent shockwaves throughout the world. And let's talk about the Supreme Court's ruling. In a 6-3 decision written by Chief Justice John Roberts, the court held that IEEPA does not authorize the president to impose tariffs. The court reasoned that the power to tax, including tariffs, which are taxes on imports, belongs exclusively to Congress under the Constitution. IEEPA allows the president to regulate imports during emergencies, but regulate does not include imposing taxes. Two of the justices who voted against Trump were actually appointed by Trump himself in his first term. That shows how legally weak the government's argument was. The ruling eliminated the majority of tariffs imposed since Trump took office in 2025, including fentanyl tariffs on Canada, Mexico, and China, reciprocal tariffs on nearly all countries, various country-specific tariffs targeting internet censorship, Russian oil imports, and other issues. For Canada specifically, this meant that 35% IEEPA tariffs on non-CUSMA goods were struck down. Here's the critical part most news coverages are missing. Canada's biggest tariff problems were not solved by this ruling. Here's talk about the tariffs that remain. The Supreme Court ruling only invalidated tariffs imposed under IEEPA. It did not touch tariffs imposed under other laws, particularly Section 232 of the Trade Expansion Act of 1962. Section 232 tariffs, which hit Canada the hardest, remain fully in effect. Steel tariffs, aluminum tariffs, automotive tariffs, and lumber duties. According to TD Economics, Canadian exports affected by Section 232 tariffs are down roughly $15.5 billion to 2025. These tariffs are causing the real damage to Canadian manufacturing, and the Supreme Court ruling did not touch them. And then, within hours of the ruling, President Trump signed the new executive order imposing a 10% global tariffs on all countries, this time under Section 122 of the Trade Act of 1974 instead of IEEPA. He later increased it to 15% via social media posts. However, CUSMA originated goods were exempted from this new tariff, which significantly blunts the impact on Canada. So yes, there's relief. Tariffs dropped from 35% to 10 to 15% for some goods, but Canada's biggest pain points, steel, aluminum, autos, and lumber, weren't addressed at all. Beyond Canada, this ruling has massive implications for how the US conducts trade policy going forward. The Congress gets its power back. The Supreme Court essentially said, if you want to impose tariffs, Mr. President, you need Congress to explicitly authorize it. This is a huge reassertion of legislative power. For decades, Congress has delegated more and more authority to the executive branch. This ruling draws a line. Tariffs are a core congressional power under the Constitution, and vague languages like regulate imports won't cut it. As Barbara Matthews from Atlantic Council put it, the ruling is both clear and broad. No part of IEEPA can be construed to authorize the imposition of tariffs in response to any national emergency. But the question now is whether Congress will amend IEEPA or other laws to explicitly give the president tariff authority. Republicans control both chambers, so theoretically they could pass legislation granting Trump the power the court said he lacks. But there's increasing bipartisan frustration with unilateral tariffs, especially among senators representing manufacturing and agricultural states. Dan Ikenson from Atlantic Council believes this ruling may trigger a more assertive Congress, which has already been showing increasing but cautious impatience with Trump's tariff approach. Here's a question nobody has a clear answer to yet. What happens to the billions already collected under the new illegal IEEPA tariffs? The US has collected massive tariff revenue since early 2025 under these now invalidated tariffs. We're talking tens of billions of dollars from businesses that imported goods under protest. Many companies filed legal objections but paid the tariffs anyway to get their goods released. Now, they want refunds. Well, the Supreme Court ruling doesn't automatically trigger refunds. That will be litigated to lower courts over the coming months or even years. For Canadian exporters who paid these tariffs, this could mean significant money coming back, but don't hold your breath. The US government isn't going to eagerly cut checks for billions in refunds. And then there's administrative chaos. US Customs and Border Protection has been instructed to stop collecting IEEPA tariffs, but processing refund claims, determining eligibility, and unwinding months of tariff collections will take time. If you are a Canadian business exporting to the US, here's your action plan. 1. Verify CUSMA compliance. The new Section 122 tariffs, 10 to 15%, exempts USMA originated goods. Makes absolutely certain your exports qualify under CUSMA rules of origin. If you're not sure, consult a trade lawyer. Now, the difference between 0% and 50% can destroy your margins. 2. Track potential refunds. If you paid IEEPA tariffs under protest, document everything and prepare to file refund claims. Work with custom brokers and trade lawyers to ensure you're positioned for the recovery. Number 3. Prepare for more volatility. As Unifor National President Lana Payne warned, the risk to Canadian jobs remains severe, for the potential to even increase if Trump looks for new ways to impose tariffs. Don't assume this ruling means stability. Build supply chain resilience, consider nearshoring, and diversify customer bases beyond the US, where possible. Number 4. Watch Section 232 litigations. Legal challenges to Section 232 tariffs are ongoing. The steel and aluminum tariffs could face similar constitutional challenges, though they rest on the different legal foundation. Number 5. Advocate to trade associations. Canadian businesses should work through chambers of commerce and industry associations to pressure both Canadian and US governments for stable, rules-based trade. The Canadian government needs to hear from businesses about the real-world damage these tariffs cause. The bottom line is that the US Supreme Court struck down Trump's use of emergency powers for tariffs in a historic 6-3 ruling. But Canada's biggest tariff problems, steel, aluminum, autos, and lumber, remain untouched. Trump immediately pivoted to new legal authority imposing 10 to 50% global tariffs, with the exception of CSMA. The uncertainty for our Canadian consumers continues. For Canadian businesses, verify USMA compliance, prepare for refund claims, and brace for continued trade volatility. If this helps you understand what's really happening beyond the headlines, hit that like button and subscribe. And I'll see you in the next one.